So our goal today is to explore some legal issues that your business should be aware of. There's a few things going on in the news as well that I'm sure we'll be touching on. But to kick things off today, I want to have each of the panelists introduce yourself and then give us one or two specific legal issues that our businesses should be watching. And so we'll go ahead and begin with you.
Good afternoon, everybody. I'm David Walker. I'm a longtime, now retired professor from Drake Law School, former dean there. I'm chair of the Iowa Bar Association's Corporate Laws Committee and been actively involved in a lot of business legislation over the last 20 years or so. I'd like to bring to your attention two recent bills, one involving limited liability companies, the other passing through both the chambers up on the Hill this year, a substantial revision of Chapter 490, which is Iowa's corporate law. One deals with limited liability companies, the other with corporations. But I say one theme that runs through them is an increase in the flexibility that the law is allowing in business and organizational structures and operations to enable business to deal most productively and efficiently with situations confronting it. I'm going to give an immediate, not the most important example from the corporate bill, is an amendment that allows corporations to have no physical annual or special shareholders meeting, but to allow them with control numbers and assurances for shareholder participation to have meetings that are totally virtual, whether the corporation is a closely held one involving 4 or 5 shareholders across the country, or is a much larger one with hundreds of thousands of shareholders. Some of our publicly held corporations, a Casey's corporation, could have a totally virtually held meeting. And at a time when the coronavirus is giving everybody concern, I think that is important. The corporate bill broadens the field from regulating just inter-corporate transactions to transactions involving corporations and all other kinds of entities, limited liability companies, limited liability partnerships, cooperatives, other forms of entities, because this is what business is doing. And sometimes it's of advantage for one form of business to convert to another form of business. Sometimes it's of advantage for a foreign corporation to domesticate to be an Iowa corporation, or vice versa. That flexibility is being introduced too. Finally, on the corporate side, the corporate bill will introduce something not novel nationally, and that is the notion of what's called a public benefit corporation. A public benefit corporation is a for-profit corporation that has as a part of its articles a mission to serve a public benefit. It could be environmental, it could be artistic, it could be some other aspect of community benefit, but it is a business corporation, it is a for-profit corporation, it is either going to be taxed as a C corporation or an S corporation. It is not a nonprofit corporation. 36 out of 50 states have these. There's been some resistance, not entirely clear to those of us at the bar have studied this very carefully. There are 36 states, over 7,000 benefit corporations, including Ben & Jerry's, Patagonia, Method, and a plethora of smaller corporations where people want to have a public purpose as well as a avowedly for-profit purpose. So that's what's happening. The LLC bill allows a single limited liability company to develop what's called a protected series, so that it would function as a single limited liability company, but with unincorporated divisions within it, which had the liability shields of separate companies. So it introduces that flexibility that I mentioned. It provides for accountability, particularly accounting accountability, so that there's no fraud on creditors, but it allows people to organize their business, whether You could be a group of owners who own several McDonald's franchises, or a family which owns several farms. You have one LLC, put each farm, each franchise, each commercial development unit in a separate protected series, and then everything is determined by contract, by your operating agreements. I think you'll see we're trying very hard to introduce flexibility and currency into our business laws.
Thank you. Jolene.
Yeah, sure. Hey, my name is Joe Whitney. I'm an attorney at the Davis Brown Law Firm, and I'm apparently on a short leash. Okay. So I'm an attorney at the Davis Brown Law Firm. I do labor and employment law, I do healthcare law, and I do data privacy and security. So I like to think that I do sex, drugs, tattoos, and all the pictures you took of that and put on the internet, okay? That is literally what my job is. So if I'm going to talk about a couple of topics, we're going to start with the C word that you're all sick of, which is coronavirus or COVID-19. I've spent a lot of time in the last 3 to 4 weeks talking about what that looks like in our emergency rooms, because I do a lot of healthcare work, what that looks like in long-term care, because we represent a lot of long-term care facilities, but also what do we have to report to OSHA? What happens with workers' compensation? If it is a workplace exposure rather than community acquired, is that going to be a work comp issue? What are we going to do with that in insurance? What does premises liability look like if we have an exposure? What about if we have a contract and we're planning to do a big event and we have to cancel it? How do we do that? All of those things affect our businesses, whether you were planning to go someplace or whether you're just fist bumping, instead of shaking hands. And so all of those things are important to how we're planning and what we're doing. And it's spring break, right? So it's only going to get worse in Iowa. Everybody's going to go someplace. They're going to visit their grandma in Washington in a long-term care facility, and they're totally coming back with COVID, okay? That is literally what's going to happen, and we want to plan for that. The other thing that I've been working with a lot lately and thinking about is really the fallout of the Me Too movement, but not just the standard what does sexual harassment look like, but how does that impact how we hire and how we hire new people or how we do mergers and acquisitions. All right, because if you go to buy a company or merge with a company or hire a higher level management person, we are getting in that place now where our due diligence involves asking if they've ever had a sex harassment complaint, if we've ever investigated that. Does the company have one outstanding? Because that's what due diligence looks like in a post-Me Too environment. You have to ask the questions. We used to ask about ERISA. We used to ask about whether or not you had any outstanding work comp claims, and now we want to know about sex harassment or racial harassment or any of the rest of it as part of that process to help us do what we need to do and not bite off a lot of liability risk that we would not otherwise want to have. So those would be the two things that I've been thinking about a lot in the last month. So.
Great. Up next.
Good afternoon, everyone. My name is Kelsey Knowles. I practice at Belin McCormick. My practice area is primarily in labor and employment and litigation. Labor meaning traditional labor law, so union work only on the management side, and then employment work, not as sexy and fancy apparently as Joellen's practice, but similar on the labor and employment side. So the two topics I want to talk about is one, sort of a follow-up on the coronavirus COVID-19 issue, and that's to touch on sort of a, I think, potentially unseen labor law related topic, which is what rights do employees have when they are scared to come to work? So employees, even if not maybe rational, have some right to work in a safe work environment. And even if they say, hey, my coworker sitting in the cube next to me just got back from a cruise and I'm really nervous to come to work, I want them to stay home or I'm not coming in. There are protections in the National Labor Relations Act for that sort of behavior as well, that sort of protected concerted activity. So this is a time where I think sometimes we can have sort of reactionary behavior to say, well, that person is just being irrational. What are they talking about? We've got it under control. And we do need to recognize that employees have a whole variety of rights out there, including some from some statutes that we don't normally think about, especially in the non-unionized employer context. The other topic I want to talk about, because it keeps kind of circling back back over the last couple years, and I've run into it a lot lately, is the impact of marijuana legalization on our workforce, especially our workforce that is across a lot of states, and especially those of you who have employees that ever get near Illinois after that statute passed and went into effect in January. So I talk a lot to employers about what that means, and it means different things to different employers. Frankly, some employers are really not that concerned. Some employers are very pro-legalization, and they want to know how to balance and incorporate that safely in their workplace. Some employers have employees who operate big, heavy equipment and drive forklifts, and they want to be sure that their employees are not impaired or intoxicated while they're doing that at work. One of the really important things is to make sure that your policies, especially if you have a drug testing policy, actually align with your goals. If you have a drug testing policy that says you're going to fire people if they test positive for marijuana, and you don't want to do that, you need to fix that policy, for example. Another thing that employers run into is those that do have employees in multiple states really have to be cautious of what those states' laws are and aware of the changes, because they're changing quickly. If an employee is on medical marijuana as a prescription, what does that mean? Do we accommodate that? Is it like a prescription for painkillers, and do we treat it the same way? That depends on state law, and I think you're going to see that evolve and continue to evolve as these laws become more common, and frankly, as we learn more about what it means in the workplace, about what it means when people are driving. All of those things will continue to evolve, and those are some of the things that I've been talking to a lot of clients about. Thanks.
Hi, everyone. My name is Todd Van Tomy. By way of background, I'm graduated in chemistry from Iowa State, and then went to Drake Law School, where Dean Walker was my dean, and we just established that I'm now officially allowed to call him David. So that's something I've earned after 23 years, I guess, and my brother also going through school. So I guess I don't get to have immediate trends in coronavirus. My background is patents, trademarks, and copyrights. So the trends that I get to see, though, are I encourage clients, especially Midwestern clients, to disclose anything new to your company to a decision maker that needs to evaluate it from intellectual property rights. And why do I say that, and say that way, is because two reasons. One, not only do you want to vet to see whether someone should be filing a patent or a trademark, but you also want to vet to make sure that anything new you're developing or a new feature of a product is not infringing someone else's patent or trademark, which is actually something that I think maybe gets a little, not ignored, but a little short shrift sometimes within corporations. The other trend that I personally do, and in our group, which I think is not unusual now maybe, but maybe a bit unusual for the Des Moines market, is we do statistical analysis. I like to call it moneyballing patent applications. So we have tools by which we can look at individual examiners and individual art units at the United States Patent and Trademark Office and examine their behavioral trends. For example, if you continue to file a response after a response in a patent application, they continue to reject, you can see that they have that behavior. But if you file an appeal immediately, they almost always allow the application because they may not want to have that analysis reviewed by someone at a Board of Appeals level person. And you can see some of that statistical data at that level. There's even a tool we've recently begun using at our office at Nyemaster Goode that you can put in an entire application, and the algorithm will run and predict which art unit in the patent office your application will be assigned to even before you file it. And then it will give you terminology to change in your application so you can direct the application to a more preferential art group. So there's a lot of new tools at our disposal that I think everyone needs to know about, and that's just one of them. So thank you.